The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having a manner or form of business for the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and get their attention, for the court is now sitting. God save the United States and this honorable court.
Yes. Okay. All right, we're ready to proceed with the first case of Willis versus, Horry versus the Horry County School District. ZW and others versus Horry County School District. We'll hear from the appellant.
Thank you, Your Honors, and may it please the Court. My name is Mary Willis, and I represent the appellant, Mr. David Warner, who is here with me today, and his minor child, who I will refer to as ZW. The issue in this case is a narrow one. The issue is whether the district court erred in holding that my client was required to exhaust administrative remedies under the IDEA before filing this lawsuit alleging violations of Section 504 and Title II. And to answer this question, all we need to do is follow the guidance of the United States Supreme Court in Fry versus Napoleon Community Schools. In Fry, the court identified two hypothetical questions, which when answered in the affirmative, indicate a plaintiff's complaint does not seek denial of a free, appropriate public education, and therefore the exhaustion requirement is not required. In this case, the district court identified the Fry factors in those two hypothetical questions, but never actually applied them to the medical necessity claims that are alleged in our complaint. So if we turn to the first question that was identified in Fry, could we have brought essentially the same claim if the alleged conduct had occurred at a public facility that was not a school, say at a public theater or a library? And the answer to that question here is an unequivocal yes. We could bring the exact same lawsuit against any other public facility if they refuse to allow ZW's ABA therapist to accompany him into those facilities to administer treatment. More importantly, his ABA provider already does accompany him into both public and private facilities to administer this treatment. And that is because autism affects him in every setting of his life, not just at school. So to treat his autism, his neurological pediatrician from the Medical University of South Carolina prescribed ABA treatment as a medical necessity at an intensity of 40 hours per week to be administered across multiple settings, including school.
What about the evaluation that the psychiatrist recommends? See, he says a school program utilizing an ABA approach. Shouldn't we infer by that at least brings in some kind of an educational approach in this matter?
Well, the initial evaluation that was provided to my client when he was around 5 years old, it did recommend ABA-like strategies in the school setting. However, his autism has regressed significantly, and he started exhibiting severe maladaptive behaviors, and he went to a neurological pediatrician this time. And so the second letter came from a neurological pediatrician, whereas the first, I believe, was from a psychologist. And so after he developed, after his symptoms continued to regress, his neurological pediatrician decided he needed ABA treatment, medical grade ABA treatment, at 40 hours per week, which needed to also be administered in the school setting. And that's important because ABA treatment itself, by definition, is environmentally sensitive, which means that, because children with autism have difficulties generalizing behavior changes, and they behave differently in different settings. And so for children that are school age, they spend the majority of their time at school. ABA treatment is ineffective and the treatment plan does not work if they are not getting that treatment in school as well as out in the community, at home, and so forth. So similar to the deprivation of any sort of medically necessary care, failure
I'm trying
to
to follow that. You keep bringing up the word school, so that seems to indicate that education is a part of this. Is that right?
I think anytime we are talking about something that a child needs within the school setting, education is obviously in some way related to the case in general. However, my client needs ABA treatment in the community. He receives it at home, he receives it at summer camp, he receives it in after-school programs. The only place right now that is prohibiting him from getting his prescribed treatment is the school right now. And the problem with that is that ABA treatment is ineffective altogether if it is not provided at the intensity that the doctor recommends, which for ZW is 40 hours per week. And if he can't get it in the school setting, any progress he makes outside of the school setting regresses.
Can I ask you what my biggest probably concern about your position is, and tell me if I shouldn't be concerned about this, and if so, why? Why isn't the implication of your argument that any time a parent wants the child's own treatment provider to provide in-school treatment, they can just recharacterize it as so like take the school nurse or the school psychologist or something like that, and they say, look, I know there's a school nurse and I know there's a school psychologist, but my child has very particularized needs, and or I would just prefer they have their own person there rather than the school nurse or the school psychologist. And that essentially gives parents with the resources and the ability to do that to provide I think you're not.
Yes.
Why should I not be concerned that you're essentially allowing wealthy parents to be able to say, I know the school has things for this, but I want my kid to have their own anytime they want to?
And I understand that is a concern, and it's a valid concern. The reason that it doesn't apply, and I don't think it'll open the floodgates to, any speech pathologist or whoever the parent chooses to come in and provide these private services. I don't think that's what's going to happen, and I think it goes back to the nature of what medical grade ABA treatment is and what it requires to be effective. And what it requires to be effective is it has to be applied at the intensity prescribed.
So let me give you an example to maybe sharpen the point. Say that my child has a learning disability, and I hire a private person to work with my child about their learning disability, and I say, I know this school has people who are there to work with children with learning disability, but it's really important that my child has the person I picked. So I would like my private tutor, or whatever the correct term for such a person is. What does your position imply that they can do that? And if it doesn't, why doesn't it? And if it does, why should I not be concerned about that?
My position does not imply that.
Okay.
I think it's specific to ABA treatment in and of itself and how it treats autistic children. That is different from children with different types of learning disabilities. And the reason I say that is because ABA treatment has to be supervised by one behavior certified analyst under one treatment plan. And so if he is not getting that treatment at home by the same person, in the school by the same person, in the after-school care program, at summer camp, it is not effective. And so ABA requires a continuity of services, which I think is...
But what does that have to do with the idea exhaustion question? I mean, now maybe it's a reason why that claim would just fail under the Rehabilitation Act, but that doesn't, the answer you just gave to me doesn't seem to have anything to do with the idea exhaustion requirement. Am I missing something?
Well, so I think the reason that the exhaustion requirement does not apply here is because we are asking for a medical service. The Supreme
But
Court...
I can characterize the learning disability tutor as a medical service. I mean, I'm sure I could get a doctor who would characterize it that way if I wanted to.
Well, the Supreme Court has held on multiple occasions that schools are not required to provide medical services under the ADA. And so I think to understand what medical grade ABA treatment actually is and what we are requesting, it's important to look at both the history and progression of this treatment over the last several decades, because both state and federal initiatives have changed the game. They've changed the playing field. Parents can now get access to medical ABA treatment that is funded both by Medicaid or private insurance companies that follow the AMA procedural codes. And both the insurance companies have agreed to pay for that in school because it has been deemed by medical professionals to be a medical necessity in order to treat autism as a whole.
Can I ask you a question? And it goes to, just want to make sure I understand this, to where Judge Heitens started. I mean, there's two questions, right? One is whether, let's say what was it, like a tutor, kind of a tutor?
Learning disability tutor.
Learning disability tutor, right? Whether you could, in the end, the parent can prevail under the ADA or Section 504, and that strikes me as a really hard case to make. But then the other question is, well, do they have to exhaust that claim. And I would think if it's something like a tutor-type person, like you might well have to exhaust that claim unless the parent has come forward with a plausible allegation that this learning disability tutor needs to be with my child not only in school, but wherever my child goes 40 hours a week. Like if I'm sending him to the movies, that tutor needs to go with him to the movies. That might not be really a credible allegation. I would think that would be part of what would distinguish your case, that at least as you have alleged it in the complaint, this is not a service that is geared toward learning. It's not about learning, at least not in its entirety. It's about safety and regulating emotions, and it extends well beyond school and well beyond the learning process. Isn't that an important distinction for you?
That's a very important distinction, Your Honor. He requires this treatment across all settings, and that's really the only way that it is effective. And that really just goes back to the nature of what autism is, and it's that autistic children have difficulty generalizing their behaviors, and they behave differently in different settings. And so they require ABA treatment, medical-grade ABA treatment, supervised by a BCBA across multiple settings so that the therapist can respond, can first of all collect data, observe them, but then respond to help ameliorate some of the problem behaviors. And when it's only done in certain settings, if it's only done at home, or it's only done in the after-school care program, and he's not getting that care when he's in school, he regresses because he doesn't have that constant continuity of treatment, which is required in order for the plan to be effective.
And we're on a motion to dismiss, right? That's the posture here?
That's correct, Your Honor.
So, I mean, we don't, it doesn't strike me that I have to actually figure out whether that is right or not, whether ABA services are more educational or more non-educational. I mean, you've alleged it in your complaint. I don't understand there to be a dispute as to whether it's at least a plausible allegation. Do we have to, tell me what, like, given this posture, how much of what you just said do I have to agree with for you to win the case?
So under the standard that was set forth in Fry versus Napoleon, essentially the question is whether or not our complaint is seeking access versus a challenge to the quality of the special education services that are being provided to ZW. And our position is that this is 100% a case about access. We have requested an accommodation from the school that his ABA provider have access to school to administer medically necessary treatment in the school setting.
And you've done so by, at least this arises from a 12B1 jurisdictional motion. You familiar with our case in KI, where we say this is a claim processing matter, it's not a jurisdictional matter? You familiar with that?
I am not, Your Honor.
Well, we did say it in KI.
Okay.
And then there's a Mosley case out of the Seventh Circuit says a 12B1 is not the matter by which you will challenge this non-jurisdictional matter, that you can only bring it up after an answer has been put it because it's an affirmative defense in this matter. Are you familiar with that?
I am not, Your Honor.
Think about it a little bit, because it's fundamental to what we are dealing with here. And KI just came out last year.
Okay.
The case Judge Qualibon just wrote, and it turned upon the whole question of, is this a jurisdictional? It creates a conundrum because, in my view, a 12B1, you ought to be able to bring up something here, but if it's not jurisdictional, I guess 12B1 goes to jurisdiction, subject matter jurisdiction, is that right?
That's correct.
And so if we have said this is not jurisdiction, you can't bring it up with a 12B1. You have to answer and make an affirmative defense on it. The question being is, what would that affirmative defense look like? And maybe it converts over to from a 12B1 to a 12B6, and then you go to a Rule 56 summary judgment type thing, because you need some evidence here as to whether it was exhausted. Here's the situation here, though. Looks to me as though your response to this doesn't even go to the question of whether you exhausted it. Because the KI case and the Moser case turns on the fact that you, in complaining this, do not have to actually state that it's exhausted. That's not your burden because there's an affirmative defense on it. But in answering this, you went straight to the whole business of as though, well, we didn't exhaust. You didn't say it, but it seems to be right on its face. something tells me if I was to ask, or someone asked directly, did you exhaust? You're probably going to say no. But ultimately, if you, let's say you don't prevail today, can't you still go back and exhaust those remedies? Or can you?
We certainly could go back and exhaust the administrative remedies under the IDEA. I think the problem with that is, well, first of all, there's been a lot of case law that has come out in the context of ABA therapy where parents have brought these claims all the way up to an ALJ, which is an incredibly timely and costly endeavor for any parent to undertake, and that the response from the ALJ has been, I don't have authority to make any rulings or decisions as it relates to medical necessity claims and access to the school.
I want you, when you get ready for your rebuttal, I want you to kick that jurisdictional question around a little bit if you can. I don't know what kind of resource you got there to look at it, but it seems to me to be key in this case, at least something that ought to be thought of. You didn't bring it up, but if it's non-jurisdictional and it comes up in this manner, how do we deal with it? But at least the keen issue of whether this fits under the FAPE situation or an idea is before us, and I think you've articulated that. Why don't we hear from the other side and let you come back because you've reserved some rebuttal time?
Thank you.
We'll hear from the appellee.
Thank you, Your Honor, and good morning. May it please the court.
Kick that can I just threw out in the middle of the road right then on jurisdiction. You are familiar with KI, aren't you?
I am, Your Honor.
You're familiar? It said this is not a jurisdictional matter, and yet this is a 12B1. Isn't that a jurisdictional motion?
Well, at the time it was made, yes. This was obviously before KI.
Well, at the time it was made, and apparently KI didn't make anything retrograde, it just told you that's what it is. It's a jurisdictional motion. You can't do this by 12B1, can you? In other words, the district court can't make a ruling on exhaustion on a 12B1. He has to wait until you assert an affirmative defense, and you've not even filed an answer. So there is no affirmative answer here, is there?
Your Honor, the response to the complaint is a motion to dismiss, right? And the motion to dismiss is based on failure to exhaust and is described.
No. 12B1 is your motion, right? That's a jurisdictional motion. You didn't make a 12B6 motion on it. It was 12B1, right?
That's correct, Your Honor.
So you can't do that. Mostly says it. The 12th Circuit said you can't do it. I mean, the 12th Circuit, the 7th Circuit says it.
Well, just a factual matter, did you move to dismiss based only on 12B1 or 12B1 and 12B6?
I'm going to actually look at the motion to answer your question.
And what difference would it make if you did not make an affirmative defense of it?
The motion to dismiss is under 12B1. I think that the question here becomes, does ZI change completely the way
Well, can an
school districts?
affirmative defense be asserted by motion as a 12B1? I don't think it can, but you tell me. You practice law a lot of it. Tell me.
Your Honor, I don't know the answer to that question. I know that whether it be 12B1, 12B6, or summary judgment, the fundamental issue here is one of exhaustion.
Yes, but it is an affirmative defense for which it arises once you file an answer with it, and you've not done that.
Your Honor, at the time the answer was filed, the law of this circuit, as I understand it, was that it was in fact jurisdictional. I think the answer was filed before Judge Quattlebaum's decision. So
Do you know, is exhaustion always an affirmative defense? Because I'm just sitting here trying to think about this. I don't think it always is, right? Is it under the Prison Litigation Reform Act? Is it under AEDPA? Is it under all kinds of I'm looking, I agree with, that Mosley does say it is normally an affirmative defense. It does not strike me as obvious that exhaustion is always an affirmative defense.
Your Honor, I don't know the answer to that question. I think here, again, and we're talking about a question of timing of when the issue of exhaustion can be engaged. When I look at Rule 8, I don't look at exhaustion of administrative remedies as always an affirmative defense. I will confess I've not researched that issue. I don't know the answer to that and can't flesh that out for the court. But I certainly don't believe, when I think of traditional affirmative defenses, I don't think of exhaustion is necessarily included in that list.
I think that's what makes it difficult. KI kicks this and says this is non-jurisdictional, and it makes that, it really puts us in a situation where we either have to clarify something or work from there. Proceed with the merits of this.
And Your Honor, I'll note on that point, the Ninth Circuit has characterized the exhaustion requirement as a claims processing tool rather than jurisdictional for years, right? It goes back, I think, to 2009, 2010. The substance of the issue, that is whether exhaustion is required in a particular circumstance, that jurisprudence holds true across the circuits. What we're talking about here is a timing issue. So I will shift to that exhaustion question. As the court knows, the question here is, does the complaint seek relief that's available under the IDEA? And
I'm not sure that that's the question, and I think it might matter. I thought after Fry, the question was whether the complaint seeks relief for denial of a FAPE.
well, I think that's another way to state the
Well,
same
it's the way the
question.
Supreme Court states it. I don't think it's the same question.
Your Honor, I don't think there's any dispute that you look to the gravamen of the complaint and you say, what does it ask for? Does it ask for educational services, or does it ask for something different?
See, I don't, it turns out this is not semantic. I don't think that's what Fry says. I mean, I understand your argument is like, look, these services, ABA therapy services, are available under the IDEA in the right circumstances as related services, so under Fry, you have to exhaust. But I just think that's the wrong question. Under Fry, the question is whether you are seeking relief for denial of a FAPE, because even like, as the court says in Fry, a service dog, a ramp, all of those things might be available under the IDEA under the right circumstances, but you're the master of your complaint. That's not what you went after. You did not sue for violation or denial of a FAPE. So I just don't see how that can be the right question.
Well, I think here that there's no question that the complaint is based in an alleged denial of FAPE.
Why, other than because you say so?
Well, if you look at paragraph 16 of the complaint says that the school district implemented a behavioral plan. We know that behavioral plans are part of the IDEA related services, special education and related services. Behavioral plans are part and parcel of IEPs and are the content of which and the adequacy of which are litigated in IDEA exhaustion all the time. Paragraph 16 of the complaint says and acknowledges that the school has implemented, quote, a variety of ABA-like strategies to address ZW's behavioral problems. The complaint says, hey, what you're doing is inadequate. You're asking for you're providing ABA-like strategies, but our preference is for something different. We want a 40-hour one-on-one person.
Up to 40 hours.
Up to 40 hours. It is very much, though, the fundamental point here is that what they're seeking is a different or preferred method of delivering behavioral
Well, I mean, you can
plan.
say that, but again, whether under 12b1 or 12b6, like there's been no discovery or anything here. And the complaint actually alleges that what they need is this medical treatment for medical, social, and emotional problems apart from the learning process to address development, regulation of emotions, ability to focus and interact, ability to maintain safety, not educational needs. And you think ABA services actually are specifically educational, and I understand that, but these are the allegations of the complaint. And I guess I don't see, like maybe in discovery that bears out, like you can prove that ABA services, this is not true. They're really all about the learning process, but that's not what's alleged in the complaint.
Your Honor, the allegation in the complaint, the court's certainly familiar with the artful pleading warning that comes with Fry. They can call it a medical procedure all they want. What we do know is that ABA services can be ordered by hearing officers, and that they are. We know that this court in 2005 in the Enrico County School Board versus ZP, the court described ABA as, quote, a methodology for the education of children with autism. That's at page 301. The court also, in the same opinion, described ABA as an approach to teaching children. We know in the Heffernan case, which Judge Wynn, you were on that panel, we know in the Heffernan case, which came out of South Carolina, that the issue there was whether ABA services were sufficient to address behaviors. It was all taken up in the IDEA context because IDEA-related services include developmental, corrective, and other supportive services to assist a child with disability to benefit from the special education.
Counsel on the other side said this is a therapy that's apparently being employed in other environments, and that what they really want is the school is the one that won't let them come in and do it, and that it really comes down to access, they're not seeking relief for denial of a free, appropriate public education. It's access that they want.
Well, what they're doing is they're trying to use the word access and conflate that with a wheelchair or a ramp. They're trying to refer and use the term access and make it like that, those two examples. There's a difference between ABA in the medical context. Autism is diagnosed in a medical context by psychiatrists using the DSM-5. There's an entire procedure where medical professionals diagnose autism. The IDEA doesn't deal with medical diagnoses. It deals with classifications and eligibility for certain disabilities. They're not the same. What they are telling you is, and they say it straight up in the complaint, if a kid needs an appendectomy and the school won't let them have it, they're denying access. Their reasoning would require the appendectomy to be performed on the lunchroom table.
What's the difference between physical versus a behavioral disability? Or is there a difference?
Your Honor, I don't know. I do know.
Wouldn't it require us to make that distinction here?
Well,
Because we know that if it's a physical disability, we're dealing with it differently, aren't we?
Well, what we do know is that this circuit has dealt with ABA therapy in the context of the sufficiency of IEPs in IDEA cases for years. So the idea that this court or this circuit doesn't have experience or know that ABA is an educational methodology that is routinely addressed when parents challenge the adequacy of an IEP, the case law is replete with examples.
Can I ask you to just walk through the two questions that Justice Kagan's opinion and Fry says we're supposed to ask and ask why they don't indicate that the plaintiff wins? So question one, could you imagine a request being made at a public library or at a public bus station? Like, is the thing the plaintiff is asking for something you could imagine being asked for at a public library? It seems to me the answer here is yes. And then the second question is, could you imagine a visitor to the school who is not a student asking for this thing? And here again, the answer strikes me as yes. Now, admittedly, Justice Kagan says the answer to these questions aren't always controlling, but they say these are a pretty good indication. And so, I mean, do you disagree that the answers to those questions here are yes, or do you think this is one of the rare situations where even though the answer to both questions is yes, it doesn't apply?
I disagree with the answer to the questions.
Okay.
And let me make a distinction here. The plaintiff wants to capture the ask as, can I bring someone to the school? In other words, if I pay for it,
Sure.
okay?
Well, that strikes me as another weird aspect of your claim, which is that the thing that the school is required to provide is a free and appropriate public education, and no one is asking you to pay for anything. So it seems weird how it would be an idea claim for it to say that I want something, but I'm not going to ask you to pay for it.
Well, what we know that who pays for it really isn't material, all right? Who pays for it? That if it's FAPE, the school is required to provide it. So I think when you ask those two questions that Justice Kagan framed, you have to ask the question, could you require the public theater or the public library to provide it?
That doesn't seem right at all, no. Take the facts of Fry itself. We talk about a person who has a dog that's assisting him. When Justice Kagan goes through that hypothetical, the hypothetical is not, could you require the theater to provide the dog?
Well, here, we don't have a body of case law that addresses this question. of whether you can be required to provide. I can tell you that a district court here in Maryland last year dealt with this issue in the context of a child with autism. And the parents wanted a communications facilitator to accompany the child at all times. And the court said, this is the District Court of Maryland, said, in this respect, the court cannot fathom how appellants could sue a library, community center, or courthouse for a certified RPM, that is communications facilitator, for failure to provide KM a trained facilitator for their autistic visitors. So again, if the court were to say that FAPE is in fact requires, if FAPE requires provision of up to 40 hours of services.
How could we possibly say that? There's no IDEA claim in this case. I don't understand what you're saying.
The IDEA claim, the question is.
There is no IDEA claim.
Well, the question is, what does the complaint say? Does the complaint request relief that is educational fundamentally, or does it?
So you read this complaint as the plaintiffs seeking public financing of ABA services for their child. That's what they're asking for.
Throughout the complaint, they refer to the educational process and the inadequacy
No, I
of the
understand.
educational process.
I understand that, but I am sort of surprised. I understand why your argument for why, at bottom, the gravamen of this complaint, this is really about educational services. But I had not gotten from your brief that you think they are actually asking the government to pay for those services.
No, I didn't mean to suggest that.
Okay.
What I'm suggesting, and I think that the complaint at paragraphs 16, 17, 22, 31, and 42 makes it clear. As I described in 16, they acknowledge that they're dissatisfied with the nature of the ABA services provided by the IEP at the school.
But
They say they don't like it. They want something different. They want their preferred approach. In paragraph 17, they question the credentials of teachers who are providing the services to the child.
I'm sorry, I don't mean to cut you off, but can I ask you a question that genuinely perplexes me, and I would like to get your views on it? This, when the district court grapples with this question, it's largely in this footnote 3, when he says, look, okay, the plaintiff is actually arguing that if my therapist can't come with me to school, I can't come to school at all. Like that, then I would have to choose between access to this school or receiving my necessary therapy and treatment, my medically necessary treatment, and so this is a real access problem. And the district court says, no, it's not, because you guys have conceded that the IDEA does in fact provide a remedy through the administrative process, and so I am ordering the defendant to afford the plaintiffs the IDEA's administrative remedy so that plaintiffs will have a choice. They won't have to forego medical treatment or remove the child from school. Well, is the district court ordering the school district to provide these services?
As I read the court's order, Your Honor, the question is whether the relief, the ABA relief requested by the plaintiff could be provided by a hearing officer. Could it be ordered? The argument or the allegation is, hey, if you don't give us what we want, our kid doesn't get to go to school.
Yeah, no.
And what the judge is saying is that hearing officers in the administrative process can determine what level and what type.
But that's not what it says. I mean, that would make perfect sense to me. But it doesn't say that. It says the defendant must afford this remedy so that the plaintiff will have a choice, will not have to forego medical treatment in order to attend school. I'm sort of slightly perplexed as to what the district court intended, and there seems to be at least a natural reading of this footnote that makes me wonder why we're even here. It sort of seems like plaintiff won.
Well, again, I think the fundamental point is the IDEA administrative process can give these plaintiffs what they want. That power exists because the services requested are educational in nature. What the complaint seeks to do is bypass that process and go straight to Section 504 or to the ADA.
So I'm just reading, so your answer to my particular question is just no. The only sensible way to read this footnote is I'm saying go see what you can get under the IDEA. I am not, in fact, ordering the school district to provide a remedy under the IDEA.
I think that's right. I don't think
Okay.
that the judge certainly, Judge Dawson isn't getting into the nitty-gritty of the adequacy of the ABA services provided and how they might be different or better. He's simply calling out the false choice of what I want or my kid can't go to school. And again, that's the important point here. The complaint seeks a different type or level of educational service, of related service, as those services are defined in the IDEA. What you have here is a plaintiff trying to sidestep that and go straight to federal court to try to turn the federal courts into the experts on educational delivery, educational content, behavioral plans, and so forth. They do that by trying to characterize this throughout as medical, medical, medical. But again, the schools provide education, including ABA strategies. This court itself.
So it is basically your position, as I'm understanding it, that if a service could be ordered under the IDEA, it could, under the right circumstances, count as related services under the IDEA. It per se may not be the basis for a complaint under the ADA or Section 504. Because I have trouble reconciling that with what Fry says.
Certainly, I think the fundamental question there is, are they educational? If they are educational and that relief can be ordered, yes, it's IDEA. And we see that in this court's
How do you
opinions.
reconcile that with Fry saying, just because you could have brought an IDEA claim doesn't mean you have to? That's not the question, whether you could have gotten this relief. The question is whether you are actually suing for violation of a FAPE.
Well,
Denial of a FAPE, I'm sorry.
the answer to the question is twofold. One, what they're actually suing for is determined by reading the complaint and what the gravamen of the complaint is. Number two, when the relief requested is inextricably linked to education, even if it could be actionable under ADA or Section 504, you still have to exhaust IDEA. You can't say, well, I can get this other places too, in addition to IDEA, therefore I'm going to bypass IDEA. That's our position, Your Honor.
Thank you very much.
Thank you, Your Honor.
We'll hear from the appellant.
Thank you, Your
Ms.
Honors.
Willis.
I will briefly try to kick around the jurisdictional question that you raised during my opening. I haven't read that case specifically, but I do think if the holding is that this is not a jurisdictional question, then it wouldn't be appropriate to affirm a decision dismissing the case on those grounds, on a jurisdictional ground. And so I think you're correct that that does put us in a bit of a conundrum now, and I understand that case came out after Judge Dawson issued his order, but from what you told me during my opening, that would be my response to that is how do we dismiss this for lack of subject matter jurisdiction if the Fourth Circuit has now issued a case saying that this is not even a jurisdictional inquiry? I think if it is more of an affirmative defense, then I think the response would be that we are entitled to move forward with discovery. And these are some of the issues that we are going to be dealing with at the lower court. It's going to be whether or not these do qualify as a medical service, which I wholeheartedly believe that they do. And then it will be his position that, this is more of an educational approach. The case law that at least he cited during his argument from the Fourth Circuit where ABA treatment was dealt with as an educational approach within the IDEA, that was a 2005 case. And so much has changed in terms of ABA treatment for the treatment of autism over that time period. Not just in terms of medical professionals moving that treatment forward, but it's become the gold standard of treatment for kids with autism and adults with autism. And that is why there have been so many states that have passed legislation now licensing BCBAs as medical professionals. That's why Medicaid, who is required to provide coverage for medically necessary treatments, have agreed to pay for ABA treatment in the school setting, in addition to private healthcare companies. In terms of whether or not the complaint was we used certain words or didn't use certain words to try to get around whether or not we were seeking a denial of the FAPE. The reason that I used words such as IEP and talked about the issues that led to my client filing this complaint is because there was a history that preceded this. And it got to the point where my client realized he was not getting what the doctor ordered, and he was entitled to it. And that is when he asked for a reasonable accommodation under Section 504 in the ADA. And that was denied without even any sort of investigation. You know, can I have some more information? Can I look at the medical records? And so I think, you know, using certain words in the complaint does not, or was not my intent to dictate that this was a case about the quality of educational services. We are seeking access for his medical provider to administer treatment in the school setting to treat his disability. He receives that treatment in all other areas and aspects of his life, and it's no different than how Wonder Dog was in the Fry case. Wonder Dog also was with that disabled student inside the school and outside the school. We are not asking the school to provide anything at all. We are simply asking for access.
Why does that matter if you offer to pay as opposed to the school providing it itself? Go back to Judge Hyten's earlier question as to, doesn't that really make at least this position something more likely to come from someone who has the means or the financial resources to do it, as opposed to children who come from poor families?
In this context, Your Honor, I think the reason that I have pushed that point is because of the progression in history of ABA treatment over the last couple decades, because there's been so much work at both the state and the federal level to get insurance companies to step up and pay for these services, because the medical professionals in the medical field are saying this is a medical necessity for a huge subset of kids with autism, and it is the most effective treatment for them. And so I pushed the comment in my briefs, and I've been dealing with the school district, is that we're not asking you to pay for anything at all. We have, all of that funding is already set up through Medicaid and private health insurers. I think one thing, when claims do fall under the IDEA, the school district is required to pay for those. That is, you know, certainly something that is true. I don't think the fact that we are not asking the school to pay for it, you know, does or does not bring it outside of that claim. I think it brings it outside of an IDEA claim because we are seeking a medical service. Medical services, the Supreme Court has held, a school district does not have to provide them. And so the medical professionals, his neurological pediatrician, have all said he needs this treatment, it's a medical necessity. And we are just asking the school to step aside and let his provider come in and provide it.
All right, thank you very much. Thank both of you. We have reinstituted our policy to come down and greet counsel, and we'll go to the next case.
Thank you.
To hear argument in the second case for the day, Chambers versus North Carolina. We'll hear from Mr. Miano.
Sure. Thank you, Your Honor.
May it please the court, my name is Bert Miano, and I represent Margaret Chambers, the appellant in this case. This case arises under 42 U.S. 1981 and 1983 and concerns the proper application of the 4-year statute of limitations set out in 28 U.S.C. 1658. In short, the question here is, does the statute of limitations for this case depend on the remedy, or does it depend on the underlying right? The district court erred.
Mr. Miano, before we get to that, which I agree is an important and difficult question in this case, could you just make sure that I understand what aspects of the district court's decision are you challenging and which are you not? Because I agree that statute of limitations issue is very important, but there are also some questions about sovereign immunity and certain whether defendants can be sued in the 11th. I just want to make sure I understand exactly what parts of the district court decision you are asking us to reverse.
Yes, Your Honor. The district court dismissed all of Ms. Chambers' claims under 1981. She dismissed claims against 2 individual defendants in their official and individual capacity. She dismissed all claims against the State Department of Justice, which was her employer.
What's before us right now?
Excuse me?
What are you
Before us
challenging?
now?
I'm sorry, I'm challenging the dismissal of the individuals in their individual capacity, and I'm challenging the dismissal of everything under the statute of limitations ruling.
But for example, if you can't sue the North Carolina Department of Justice because the North Carolina Department of Justice has sovereign immunity, then the statute of limitations doesn't matter with regard to the North Carolina Department of Justice, right?
Yes, Your Honor, but we also sought prospective relief in
Sure, but you can't seek even prospective relief against the North Carolina Department of Justice. That's just not a proper defendant under 1983.
I understand, Your Honor.
that right?
So are you challenging, I guess I'm saying, are you challenging that holding, that you just can't sue the North Carolina Department of Justice?
No, Your Honor, we're challenging the holding that the dismissal of the individual defendants and the statute of limitations issue.
And this is so far as the Section 1981 right that is being, that comes through Section 1983.
That's right.
That's just it, not the other, okay, all right.
So not the constitutional claims, those are out of the case?
That's right.
Okay. So it's just 1981, which means it's just race discrimination against these 2 individual employees, is that right? The 2 individual defendants?
That's correct.
Okay.
So the district court applied the 2-year statute of limitations set out in the state personal injury statute in North Carolina.
Did you say 2 or 3?
I'm sorry, it's 3 years.
3, okay, sorry.
This case was filed just under 4 years after Ms. Chambers was terminated. So whether the 3-year of the North Carolina state statute or the 4-year of the federal statute under 1658 applies, determines whether this case can proceed against the individual defendants. The district court did not discuss Jones v. R.R. Donnelly, which is a U.S. Supreme Court case that was decided unanimously in 2004. In that case, the court construed 1658 very broadly to say that any case which arises under an enactment post-1990 gets the 1658 statute of limitations, which is 4 years. Ms. Chambers' claims are all post-contract formation claims. They are under 1981. Before 1991, post-contract formation claims were not possible under 1981. Those were enabled by the Civil Rights Act of 1991. So they didn't exist prior to that. That was a reversal of the Patterson decision by the U.S. Supreme Court. In Jones, the Supreme Court construed the language arising under or arose after enactment to mean that any statute that either didn't exist prior to 1990 or that was amended and the actual rights changed after 1990 so that a claim would be made available after 1990 that was not available before that, that meant that 1658 applied and the 4-year statute of limitations would apply. No circuit court has directly addressed this other than the 11th Circuit. Because there's a unique twist in this case, of course, we're suing a state actor. And that means that it's not just a 1981 claim, it is a 1981 claim brought through the procedural vehicle of 1983. And the 11th Circuit is the only circuit that has addressed that specific set of facts and that specific procedural posture. In Baker v. Birmingham School Board, the 11th Circuit held that the 4-year statute of limitations set forth in 1658 must be applied because of the broad language in Jones, which was a unanimous Supreme Court decision, and because the specific elements of the claim in the case arose out of the 1991 Civil Rights Act. That is to say, the 1991 Civil Rights Act amended Section 1981 and added additional claims. Before 1991, only pre-hiring claims were available under 1991. 1991 Act changed that so that 1981 claims could include post-contract formation claims.
Is all this to say simply, this action is one that came after 1990? Therefore, it has a 4-year statute of limitations, and that's kind of it?
That is it, Your Honor. The case law is...
You've got a lot of words here that saying the same thing sound like me over and over again. I'm not saying that you can't, but I'm just, if what you're saying, it follows logically there, I mean, it could not have existed for 1991 if you got a right that comes up then, and that's what they assert. And then if it is in fact the case that actions that the case, that the Jones case applied to matters coming up in 1990, could not have existed for 1990. So you've said that. Well,
I have, Your Honor, but
you want to amplify it on a little bit more? How do you want to move from there? Or maybe wait to see kind of what the other side say?
I'm sorry, Your Honor. The issue really is that the combination of 1981 and 1983 is what led the court, I think, to make its decision that it would dismiss the claims based on the shorter statute of limitations. 1983, of course, does not have a statute of limitations. It typically borrows the appropriate state statute for personal injury torts. That's what the district court did here, which led to the decision to dismiss the claims. If the court had construed Jones in the way that I'm suggesting it should be construed, and the way the 11th Circuit construed it, the court would have applied the 4-year statute of limitations. It's the combination of a 1981 case, which clearly 1981B, which is the amended section, 1981B would clearly get the 4-year statute of limitations, and I don't think there would be a dispute about that. The question here in this case that I think where the district court erred is that because this case was brought under 1983 as the procedural vehicle to get the claim against the state actor, the 1981 claim against the state actor, they applied, instead of the 1981B statute of limitations, they applied the 1983 statute of limitations. And I believe that's error, and that's what we're here for.
Well, can I just go back to something we started with, and I just want to make absolutely sure I have this right? Are you continuing to pursue the official capacity claims against the individual defendants?
No, Your Honor, we're pursuing the individual capacity claims.
Okay, so, but are you still seeking reinstatement?
It is my understanding that one of the two, Ms. Pendergraph, one of the individual defendants, is still in a position where she could order reinstatement, so we are still seeking
Doesn't it seem
reinstatement.
bizarre to order an individual defendant to grant a remedy of reinstatement of employment? That just seems real weird to me. Like, tell my former supervisor that they need to rehire me in a case in which my employer is not a party? Doesn't that seem weird?
It is an odd posture, Your Honor.
Is that allowed?
I believe that Ms. Pendergraph would have the authority to make that remedy, and I believe that that remedy would not violate the immunity claim of the state.
I might agree with that if you were pursuing an official capacity claim, but I guess that strikes me as an official capacity claim that maybe you're allowed to bring because of the Ex parte Young exception to the 11th Amendment. But if this is the reason I asked you, if you are abandoning your official capacity claims, because I think the answer might matter in terms of whether or not you have a viable claim for reinstatement or not.
Understood, Your Honor. We have not dropped the claim, the official capacity claim officially. It was dismissed as part of this motion that we're appealing.
I don't know, did you drop it
And-
unofficially?
and on the
I don't
appeal,
understand
no.
what you're talking about.
No, on appeal, we have not, we raised the issue in our brief.
Right.
Okay.
And we seek to apply the ex parte Young doctrine to escape the immunity issue and pursue the equitable claims against the state as
The
well.
question is, can you bring an official capacity claim for prospective relief, the reinstatement type thing here? That's the differentiation here. You said no official capacity. If you're not in official capacity, I think we go back to Judge Hyden's point. How does an individual do this? So either you're pursuing an official capacity for prospective relief, which would be reinstatement, that much we could understand. At least I would.
Yes, Your Honor, perhaps I misspoke. What we're seeking is, as we go forward, if we get the statute of limitations applied and the dismissal reversed, we would seek to pursue reinstatement against the state and the individual defendants.
I thought you agreed that the state's can't be a party to a 1983 suit.
Well, I believe they can under the exception set out in ex parte Young.
Oh, okay, so what you mean is you would pursue your official capacity suit against the individual defendants for prospective relief in the form of reinstatement.
That's correct.
Okay, I almost hesitate to ask this, but are you seeking damages against the individual defendants in their official capacities?
No.
Okay.
We're seeking damages only against the
Great. Okay.
individual defendants in their individual capacity.
Thank you.
For our purposes here, if we were to agree with you that the statute of limitations is 4 years, do we need to go any further? All these other issues, do we just send that back to the district court? Is there more for us to decide in terms of sovereign immunity and other issues?
Your Honor, I would say that if you reverse on the statute of limitations issue, you would reverse and remand for the court to address the immunity issues. Because the court really neglected to address those in substance, given its decision on the statute of limitations issue. That was the primary finding in its order, and the primary reason that it dismissed all claims without differentiating between individual claims or prospective relief claims.
Thank you. We'll hear from the appellee, Mrs. Henderson in this case.
Thank you, Your Honor. Good morning, and may it please the court. My name is Tamika Henderson, and I represent the North Carolina Department of Justice and individual defendants Robin Pendergraft and Timothy Rogers. This court should affirm the district court's grant of dismissal for two basic but very sound reasons. First, 1981 claims cannot be asserted against state actors. Second, because
So that
1980...
gets rid of the Department of Justice.
Yes, and it sounds to me like my colleague has abandoned his claims.
So we'll clear that. We're now talking about the individuals.
Correct. And second, because 1983 is the exclusive remedy against state actors, and this court's precedent supports applying the 3-year North Carolina personal...
1983 give you a remedy, or 1983, I didn't think it did anything except allowed you to assert rights. So you either got to come under the 14th Amendment or some other. He's not bringing that. He says it's section 1981. So isn't that the right in which you have to go? If 1983 only empowers you to use section 1981. You don't get anything from 1983 because it doesn't even have a statute of limitations in anything, right?
That's correct. That's why this court has always applied the 3-year North Carolina personal injury statute of limitations to 1983 claims. And there is a dichotomy between the rights under 1981 and the remedial statute 1983. And so if I could just start there, I think it'd be instructive to look at the complaint and what the plaintiff has actually alleged in this case.
And this is in light of Jones.
Correct. So under count 1, the plaintiff alleged wrongful termination in violation of the First and 14th Amendments. It seems like he's abandoned that claim, but I think it would be instructive for the court to understand that under this court's precedent, count 1 would apply the 3-year statute of limitations.
We want to talk about count 2, right? The 1981.
Correct, but
we probably could agree with you on count 1, that, if you were dealing with just 14th Amendment and that sort of thing, you got it.
correct.
This is section 1981.
Correct, but I think it illustrates the absurd result that would happen if this court adopted my colleague's invitation to impose the four-year catch-all limitations.
The absurdity is that you, just to make sure I understand that correctly.
Okay.
The absurdity would be that basically the same claim would be untimely if brought under 1983 and the 14th Amendment directly, but would be timely if brought under 1983 via 1981. Is that the absurdity?
Correct.
But we have that absurdity all over the place. So for example, your Title VII claim can be time barred, but your 1981 claim, I mean, maybe as a matter of, does the universe make a lot of sense? Maybe not, but it's routine that the same person could have some claims that are time barred and some that are not, right?
Under the same
Sure,
remedial statute.
Well, let me give you this. If I claim that I was discriminated against based on my race by my employer in firing me, I have a claim under both Title VII and 1981.
Correct.
It is absolutely possible that my Title VII claim is time barred and my 1981 claim is not. That's right? That's completely possible.
That's completely possible, but in this case, you'd have claims brought via 1983 because you would be enforcing count one under 1983 also. You'd have two claims brought under the same remedial statute having two different statute of limitations, and that's the absurd result. If I could just...
Can I just in terms of absurd results, isn't there on the other side, I don't know if I call it an absurdity, but something of an anomaly, right? The Supreme Court already held in Jones this exact Section 1981 claim is governed by the four-year statute of limitations, and that would apply to every employee of a private employer in the country, but if you happen to be employed by a state employer, you have a different statute of limitations. That seems weird.
It's actually not weird, and I think that's one thing that distinguishes Jones and why it should not be applied in this case. First, Jones was against the private actor. It was directly under 1981. This court has ruled that 1983 is the exclusive remedy against state actors, and that's why district courts have routinely said 1981 claim against state actors merges with 1983, so they totally disregard 1981 and they look at 1983. And because Jones was against a public employer, the Supreme Court did not address the issue that we see in this case, which is, does a plaintiff who is using the remedial measures of 1983, does the statute of limitations from 1981 apply in that case? Of course, they didn't have the opportunity to address that in Jones, so I don't think Jones is applicable in this case. And if I could just, for a minute, discuss the 11th Circuit's decision in Baker and discuss why this court should not adopt that reasoning. First,
In other words, you think Baker is just wrongly decided?
it's wrong, and I'd like to tell you why. It's threadbare, and it doesn't withstand even the slightest scrutiny. And the 11th Circuit gave two reasons for imposing the four-year catch-all statute of limitations in Baker. The first reason they gave was Jones. And they said that, well, Jones urges an expansive application of the four-year statute of limitations. That's not exactly what Jones said. If you look at Jones, the Supreme Court was reviewing a lower court's decision that said the four-year statute of limitation applies to causes of actions enacted after 1990. But in Jones...
Wait, that's not what Jones, I'm literally looking at
Yeah.
page 382 of Jones right now, that says, we conclude a cause of action arises under an act of Congress enacted after December 1, 1990, and the four-year statute of limitations applies. Here's the language. If the plaintiff's claim against the defendant was made possible by a post-1990 enactment. That's what Jones says is the test for whether something is governed by 1658. I don't see any plausible argument here that this plaintiff's claim was not, quote, made possible by the post-1990 amendment, because if they had brought this claim before 1990, they would have been dismissed under Patterson. So what am I missing?
Correct, but, and if you look what the court was looking at in Jones,
I'm not looking at what they're looking at
Yeah.
in Jones. I'm looking at the language of the
The
Supreme Court
lang-
about what the statute means.
Correct, and the reason why they use that language is because the lower court had said it only applies to causes of actions enacted after 1990, and the Supreme Court said, no, it's more expansive than that. The language you just used, it applies to even amendments if it was made possible by any enactments, including amendments after 1990.
Well, and then the
My argument is that this cause of action was not made possible by any amendments to 1981 because the causes of action, he has to assert it under 1983.
But it doesn't say cause of action. So you keep changing the words of the Supreme Court. What the court says is not that the cause of action was made possible. What they say is the plaintiff's claim against the defendant. The claim is the underlying substantive basis for relief. It's not the procedural mechanism by which you vindicate it. And the claim was made possible by the 1990 amendment.
I would argue that the claim was not made possible by the 1991 amendment because any claim under 1981 against state actors is not possible. It has to be under 1983. And the Supreme Court has said in Abrams, which the 11th Circuit cited, that it doesn't matter the rights
Let
that
me ask you this. Could this claim have been brought before 1991?
no, because it's a
Why is that? You had 1983 was here. You said it's made possible by 1983. Why couldn't bring it by 1983 as a vehicle for this claim before 1991?
you could have brought this claim
How?
under 1983.
How? What would have been the right that you would have asserted as a basis for 1983 being a vehicle to bring this claim? How would you bring it? 1983 in of itself is not a right. You can't assert 1983 rights. It is a vehicle by which you assert rights under the Constitution. And if this was created by an amendment in 1991, you correctly stated you could not have brought it before 1991. Under 1983 or nothing else out there. So when it's actually enacted, then you can use 1983 to bring this action that's created in 1991. That's the point I think Judge Hyten is trying to make.
I see your point.
That's hard to argue against. You do know that.
I see your point, Judge Nguyen, that because this was a post-contract, but this court in Dennis v. Fairbanks says that 1983 is the exclusive remedy. And I think what we're seeing is what comes first, the chicken or the egg.
1983 is kind of hollow. It's a nice vehicle. I mean, there's a lot of history on 1983. It's a vibrant section. It's a beautiful section, my perspective. But what it doesn't do, it doesn't have the rights there. It gives you a vehicle to get the rights. And it's only when those rights are created you can then assert it. This one, under 1981, is not created to the 1991 amendment. That's the point, is that, and then you get Jones to say everything post-1990 is covered under the 4-year statute of limitation. That's a lock, isn't it?
That is a lot. And
No, I mean a lock. L-O-C-K.
Oh, a lot. Oh, not a, I'm going to say it's not a lot, Judge Nguyen, and I'm going to go back if I can.
Go back and show us why it's not a lock.
Yes,
Looks like a lock to me.
argue.
Can I actually ask you, I think this will be related, so I don't want to pile on, but it could be
Okay.
part of your answer. So it's not just that 1983 is sort of like an empty vehicle, it's that you get under 1983, the defendant, state employer, gets 1983 defenses, gets qualified immunity. That, I thought, was sort of the point. Like, on the upside, the state defendant, the reason we make people go through 1983, in part, is so that the state defendants will have the ability to raise 1983 defenses like qualified immunity. But that seems to be, I'm not sure I can even, what I want you to address is it's sort of like you get your defenses, like that's what you get by virtue of JET and having to go under 1983. You don't get a different statute of limitations.
So I agree that we do get the defenses under 1983, but we are not arguing for a different statute of limitations. I agree, Judge Wynn, that Jones clearly says after 1990, if the cause of action arises after 1990,
Nice 4-year statute.
the
of limitations.
four-year statute of
And
limitations.
you agree this action was only possible after 1990?
Because it's post-contract. Yes.
Because you didn't have an amendment until 1991.
And I know you won't think much of this argument, but 1983 has not been amended. And I go back to that. 1983 has not been amended.
I think maybe where we might be disagreeing is what is 1983? Any right, 1983 alone, you will never see it asserted, you have a right under Section 1983 and move forward. You have to put some right, a law under that in order to enforce it. So you use the constitutional vehicle to do it, or the law vehicle. Here, the law is this 1991 law. That's the thing, is you go back to 1983, but substantively, as I say, it's a beautiful vehicle, but it only empowers you to assert these rights. And you got to put the right in there. If you don't put the right in there, you don't even get in court.
I see what you're saying, but if I could go back to the 11th Circuit decision in Baker, and they relied upon, in a footnote, a different Supreme Court case, Abrams. And in Abrams, the plaintiff was attempting to assert a Telecommunications Act violation via 1983. And the Supreme Court addressed the question, well, can you do that? And they said no. And one of the reasons why Baker relies on Abrams is in a footnote in dicta, the Supreme Court mentioned trying to exemplify why the TCA could not be asserted via 1983 when it had a 30-day statute of limitations. It said it could be that maybe the 4-year statute of limitations applied because of what we've said in Jones. But they were saying, what they also said in Abrams is that the 1983 action does not depend on the federal statute that is being enforced, which would suggest that the 1983 is always subject to the state statute of limitations. If the Supreme Court has said that a 1983 action does not depend on the federal statute that's being enforced, then I think that supports my argument that this claim does not arise under the amendments to 1981. If the Supreme Court has said it does not depend on the 1983 action does not depend on the underlying federal statute that is being enforced. And I think that supports my argument that you continue to apply the state's statute of limitations.
Thank you very much. Appreciate your argument. We will hear from the appellant, Mr. Piano.
Just a couple of additional points. Jones, as we've discussed, was decided very broadly. It did not include the 1983 issue in that case, but it was otherwise, it defined the application of 1658 very broadly. And in a decision a year later, the Rancho Palos Verdes decision, Justice Scalia said in dicta that he was referring to a TCA claim brought using the vehicle of 1983. And he said, since the claim here rests upon violation of the post-1990 TCA, Section 1658 would seem to apply. Now, they decided that case based on the fact that, on a TCA question, rather than the statute of limitations issue. So that particular sentence that I just read to you is not the holding in the case. But it does reveal that the Supreme Court's conclusion in Jones, which applied the 1658 4-year statute to a 1981 claim that arose after 1990 without the vehicle of 1983, would likely be applied, at least by Justice Scalia, to this case because it has the 1983 vehicle, with the 1981 rights for post-contract claims plugged into the vehicle. That particular set of facts is the nuance here. I think Baker v. Birmingham obviously was decided correctly. It does not just rely on the broad language of Jones, but it relies on half dozen or more district court cases that also reach the same conclusions. A few district court cases reached the contrary conclusion, but the Supreme Court's language in Jones regarding the uniformity of statute of limitations and people being able to have certainty about how long a statute of limitations should be leans in the direction of applying the consistent 1658 statute to all 1981 post-contract claims that are brought under 1983, regardless of what state they're brought in. If you rule the other way, every state is going to have a different statute of limitations for post-contract formation claims under 1981, and that is against the uniformity provision that the Supreme Court clearly wanted to enforce under Jones. Thank you.
Thank you very much. We'll come down and greet counsel. Proceed to the third case of the day. To hear argument in the third case of the day, Carrera versus EDM Sales. We'll hear from Mr. Garcia.
Good morning, Your Honors, and may it please the Court, Eduardo Garcia, on behalf of the appellants and cross-appellees, EMD Sales, Inc., and Elda Divari. There are three topics that I will be covering during my initial argument. The first is that the district court erred in applying the clear and convincing evidence standard to an exemption of the FLSA. The second is that the court erred in finding that the CEO/owner's lack of knowledge of an employee's responsibilities is dispositive for the liquidated damages analysis. And third, I'll be addressing the cross-appellant's argument that the court erred in finding that the violations were not willful. So we begin with the clear and convincing evidence standard and its application by the district court. The first part of that argument focuses on our contention that this court never appropriately adopted the clear and convincing evidence standard.
Can I ask what work the word appropriately is doing in that sentence? I mean, we adopted it. We said it was our holding, and I believe there was a case where we were required to clarify, like, that means we adopted it, it's our holding, and one panel is bound by it.
Sure.
So what was inappropriate about what happened there?
Yeah, if you look back at the case law regarding this issue, Your Honor, Clark v. J.M. Benson is where this all traces back to. And in that case, this court did not find that the clear and convincing evidence standard applied. What the court did state was that the employer bears the burden of proof. And that was its holding. In that case.
Just so you're, as I understand it,
Yes.
on this first point,
Yeah.
your argument is, yes, it is a holding of the Fourth Circuit that we apply the clear and convincing standard. But when we held that, we were wrong.
It's not that the court was wrong, it's that the court.
Misunderstood the precedent it was looking at.
Respectfully, Your Honor.
But here we are, like, you do understand, right, here we are, and as we did clarify in Desmond, right or not, that's the law of this circuit as of now.
Yes, but
Okay.
it is important to understand the background of how this court got to here, which is that J.M. Benson relied on the Donovan case, which said clear and affirmative evidence.
Okay, I guess you can just posit for purposes of this argument that I am completely convinced that we are totally wrong, that clear and convincing is absolutely the wrong legal standard. So you don't have to try to convince me of, and I think you actually do, and the Seventh Circuit does a nice job of explaining how this mistake happened, and it's completely wrong, and it's a complete misreading of a Supreme Court decision. Let's posit I agree with all of those things.
Okay.
What can I do about that? I mean, I guess, given what just Judge Harris asked you, and maybe we could have said the first time we said it was dicta, even though we actually applied it, but then we literally, but then we had a case 2, and case 2 is what is the holding of case 1? And case 2 says the holding of case 1 is X, and we don't have the authority to depart from it. So now, aren't we not only bound by the holding of case 1, but also the holding of case 2, which says the holding of case 1 is X?
So 2 answers to that question. First, Your Honor, to the question of what should we do about it, you should correct it. The mistake was made, and we should move on from the mistake and adopt the correct standard that should be applied in these cases. And that's why it's important to figure out first, did this court erroneously go backwards? That's the first route that this court could take in saying this panel has authority.
That is not a route we can take. I know you're about to get to your second route, but I am perplexed as to why you're sticking on your first. That is actually not a route that is available to us as one panel of the Fourth Circuit. We cannot go back and say Desmond was incorrect, so we're just going to come out differently today.
Okay. Well, understood, Your Honor. So I'll move to the second point, which I think makes the whole issue kind of moot on whether the court was wrong in the first place. There was an intervening Supreme Court case which automatically gives you guys the ability to deal with the issue. So let's focus on that actual case and what it said and why it changes it, and then also look back at the other cases and this court's own rationale to understand why that Supreme Court changed everything, and there is no need for the clear and convincing evidence standard. So that case is Encino Motor Cars, LLC. And in that case, the Supreme Court focused on what other courts had mistakenly been looking at, and in fact, we would argue this court was one of those courts, in focusing on the idea that the employers bear a higher or heightened burden, such as the clear and convincing evidence standard, when it comes to the exemptions. In Encino, the Supreme Court told us that the Ninth Circuit was erroneous in relying on the principle of narrowly construed against the employer. It emphatically stated, we reject this principle as a useful guidepost for interpreting the FLSA. So now we have the Supreme Court affirmatively, undoubtedly telling us that doesn't apply. Walling and Ben Kanowski, in which are the bases of where the courts relied on the Supreme Court's prior precedent to put a heightened standard on employers, those do not apply. The Supreme Court further says there's no narrow construction. Exemptions are entitled to a fair reading, and they are treated as much a part of the FLSA as the overtime pay requirement.
But that's a holding about statutory construction. It's not a holding about who bears the burden of proof.
Well, Your Honor, that is the concept that the court is talking about, but it does go further than that because it says, again, we reject this principle as a useful guidepost for interpreting the FLSA.
The principle is a principle of statutory construction, like the principle that waivers of sovereign immunity should be construed narrowly or criminal statutes should be construed to favor the defendant. So maybe that's take these. The rule of lenity is a principle of construing criminal statutes. It does not tell me who has the burden of proof at a criminal trial or what that burden of proof is.
And Your Honor is generally spot on with your analysis about understanding what the principles of textual construction. The one differentiator that I would say is, in fact, that the courts, including this one, have relied on those principles of statutory construction such as the narrowly construed doctrine, such as the plainly and unmistakably doctrine, such as the clear and affirmative doctrine, in order to come up with the clear and convincing evidence. And what's instructive is to look at what other circuits have done.
Well, can I stop you on that one?
Yes, Your Honor.
Because before Encino, there were a couple of circuits that were not applying clear and convincing. They were applying preponderance, but they were applying the narrow construction rule, which was the rule until Encino. And they have explained to us, why those are two very different things.
Well, first, it is important to note what the other circuits are doing. The 11th Circuit started all this in 1991, applying preponderance to exceptions as the burden. That was in Dybach v. State of Florida Department of Corrections. Then we went to the Second Circuit, the Fifth Circuit, the Sixth Circuit, the Seventh Circuit, and the 10th Circuit. All affirmatively apply preponderance of the evidence. Yee and Letterman are the two that this court should particularly focus on, because Yee goes into the analysis of how this all got garbled up and all the discussion of clear and affirmative evidence and the discussion of plain and unmistakably led to some people believing that it was a heightened standard, which was erroneous. And Letterman overturns in the 10th Circuit Donovan v. United Video, which is the one this court initially relied on in J.M. Benson for the clear and affirmative standard. And in that case, it states, in sum then, just as some courts have mistakenly viewed clear and affirmative evidence as a heightened evidentiary standard, the same is true with the phrase plain and unmistakably. They do not establish a heightened evidentiary requirement on employers seeking to prove an FLSA. The jury should have been instructed to consider the evidence under the preponderance standard.
Can I ask you a question, counsel?
Yes, Your Honor.
So I do think that some of this case comes down to, how do we know when the Supreme Court has kind of implicitly superseded one of our precedents? So we have this precedent saying clear and convincing, which, at least for current purposes, let's assume that we are, as one panel of the Fourth Circuit, bound by Desmond. So we have that. You're not disputing, or are you, that we could go forward from Encino and both apply Encino's rule of statutory construction. We do not, construe the exemptions narrowly. We just give them a fair reading. And also apply the clear and convincing standard, evidentiary standard. That is practically possible. Those are two different things.
I do not believe those are two
How are
different
those
things.
not two different things? Our standard of review, we apply a mixed standard of review in these cases. We review the legal question of what the exemption means de novo, and then we consider the factual question, who has shown what about whether they fall within the exemption. So construed, we say that is a different question, and we review that for clear error.
Sure. So first, there is no basis in the FLSA to apply a heightened burden on the employers.
Okay, that is a different question from what I'm asking you. I am just asking you, as a practical matter, is it not the case that one court can say two things are true? As a matter of statutory construction, we apply the fair reading test from Encino, and when we measure evidentiary burdens, we apply the clear and convincing standard. As a practical matter, those two things are not in conflict.
There has to be a basis, though, Your Honor,
I
for applying
understand.
the clear and convincing.
I totally understand, and that's the next question I want to
Okay.
ask you, but can you answer my first question? We can do both. It's not
Fair-
untenable to have those two rules coexist.
As long as there is a basis for applying a heightened burden requirement.
Okay, so your argument is not that it's untenable in that practical way. You think Encino makes it impossible to justify the clear and convincing half of that.
Yes, Your Honor.
Okay, and that has to be sort of clear enough, like we say this in our cases about when we have been superseded by the Supreme Court, like it really has to be untenable. It's not enough that starting from today, with the benefit of Encino, I might never have adopted clear and convincing. We have to be convinced that the Supreme
Yeah.
Court has implicitly told us, stop doing that.
They have. We reject this principle as a useful guidepost for interpreting the FLSA. That is
What principle?
What principle
Clear
are you
and
talking
convincing?
about?
the principle of narrowly construing the FLSA
It
and its
doesn't speak
exempt.
to evidentiary burdens.
Respectfully,
The district court brought that out, says, didn't even mention this preponderance standard in it, did it?
it did not, Your Honor, but this is the only rationale that
It may
this
be the
court-
only rationale, but we are directly on point with precedent from this court that tells us what that standard is. But to apply that standards, we then look to see if we can use the Encino narrow approach to these cases here.
So
It doesn't exclude it. In other words, as you said, it doesn't make it untenable. It makes it maybe uncomfortable, makes you don't feel comfortable with it a whole bit, but we have precedent on point.
It has removed any foundation upon this court could rest in order to maintain the clear and convincing evidence standard.
Let me ask you, at the end of the day, you must feel pretty confident you do not prevail by using that standard as opposed to preponderance. Is that correct?
But we did not prevail. This went to trial.
That's what I mean. So you must think if you don't get that other standard, you couldn't prevail.
Or we didn't prevail. It's not a hypothetical. But we don't know whether we would prevail under the preponderance
I
standard.
understand you did. And many times when people come here, that's why they're here on your position, because you didn't prevail.
Sure.
The question is, do you think you should have prevailed under that, even using that standard?
We have not appealed that issue, Your Honor.
Okay.
But that's.
I mean, you get my point? I mean, you say we didn't prevail, therefore we couldn't prevail on it. That's what we hear up here. When people sit in your position is, you didn't win below, you didn't prevail below, so now you argue you should have prevailed. But you're telling me you have not even questioned as to whether if you apply that standard, you don't prevail.
I understand that question, Your Honor. Yeah, we're not trying to overturn that would be an entirely different standard that we're not here. All we're saying is Encino did away with any foundation that this court could have used explicitly, implicitly, in any way. If this court looks back and tries to justify clear and convincing evidence as a heightened standard against employers, there simply isn't anything left. Ben Kanowski is out, Walling is out. And so that's where we are. I would briefly like to note that, again, I think Letterman makes this clear, Yee makes this clear, on the employer's lack of knowledge being dispositive for the good faith issue. The employees heavily rely on Martin v. Cooper. I would tell this court that Brooks v. Village of Ridgefield completely said that that was the same Third Circuit, that there are situations in which the employer can have no knowledge and have presented enough evidence of good faith and reasonable grounds in situations where they retain a lawyer, they negotiate with the union, and which they correctly rely on the assistance of counsel. And I'll get back to some of this in my rebuttal time. Thank you, Your Honors.
Thank you, Mr. Garcia. We'll hear from Mr. Malahi. Did I get that right?
Yes, Your Honor.
We'll hear from you.
Good morning, Your Honors. My name is Omar Malahi, and I represent the appellees and cross-appellants here. I'm going to start with the willfulness issue here. The district court made an error of law when it found that the violations were non-willful for three reasons. It did not correctly apply the applicable legal standard. It failed to make necessary predicate factual findings, and it ignored key undisputed facts that should have been part of the analysis. The court should have made a finding on EMD's level of knowledge of FALSA, because the reckless standard, which is the one that we're discussing now, requires that EMD have some knowledge of FALSA. Knowing it's in the picture, we know isn't enough. But once you get beyond that to specific knowledge of FALSA, that is a material fact which has a bearing on whether the employer is then obligated to inquire further. So in this case, the trial court made no findings on that issue and should have. The record showed that the CEO had extensive knowledge of FALSA here as it applied to the sales representatives. The CEO knew not only that it required overtime, but knew about the exemption even indicated at one point she looked at some DOL checklists.
So you're saying knowledge of FLSA, when you add that to the failure to take these reasonable steps to ensure compliance, that is willfulness.
Yes, Your Honor.
What about Richland Shoe? Seems to me it said something a little different.
Well, Richland Shoe made no finding, one way or the other, on whether the facts in that case met the requirements of willful or not. It remanded it to the court because the court applied the wrong standard. It's also important to note, Your Honor, that McLaughlin versus Richland Shoe adopted specifically the standard in TWA versus Thurston, which was an ADA case, but it was the same willful issue. There's also a regulation promulgated by DOL, which is 29 CFR 578.3. And there's also the Chow case from this court. All of those indicate that when you're talking about the reckless standard, the first step is to determine the level of knowledge that the employer had of FALSA requirements. And then the next step is to determine whether they took action. So once you get to this level of knowledge is like a continuum. We know from Richland Shoe, knowing it's in the picture is not enough. But you get to a certain level of knowledge and you don't do anything, that is willful. And here in this case, not only did the CEO know all about FALSA, but the CEO reviewed and approved a handbook dated September 2014, and there was some evidence that that handbook had been previously drafted, and that was just a later version. That handbook said, we are going to determine for our employees, and many of them were sales representatives, whether or not they're exempt. And we determine that by looking at the duties. So that's an admission. That's an undisputed fact. And this, as the district court found, the employer took no steps whatsoever to ascertain the duties and responsibilities that the sales reps were executing every day, and failed to make any determination on when, if ever, they made actual sales. So that meets the willfulness standard as a matter of law. And that's what I'm asking that this court rule, because of this knowledge, because EMD clearly knew it had to look at the duties and EMD failed to do so with a specific high level of knowledge of FALSA. And there's another issue, and that is that the district court failed to make any findings about complaints. Mr. Faustino Sanchez Carrera, one of the plaintiffs in this case, testified that 3 to 5 times he complained to Freddie Rincon, who was director of sales and a key account manager, about failure to pay overtime. And Mr. Rincon never testified, so that testimony was unrefuted. He also testified that he talked to the CEO directly about not getting overtime and at a meeting. Now, that is disputed. The CEO denied that. But the court made no findings on that, and that's complaints, and that's a key material fact on the willfulness calculus. The next issue that I would like to address, unless the court has any questions on the willfulness issue, is the good faith. I'm going to be very brief. For the same reasons, the court was correct in finding that the defendant, that the appellants did not meet their burden of proving good faith or reasonable grounds for believing they were complying with the law. And it's really the same reasons. The CEO knew about FALSA. Her own handbook required her to look at the duties. She did absolutely nothing. And that is not something the other side is disputing, that there was no investigation. So that part of the court's ruling should be upheld. As far as the clear and convincing evidence issue is concerned, I only have one thing to add unless the court has questions, and that is the appellees introduced a lot of evidence on this point, and the appellants introduced very little. But the exemption was not satisfied, did not even come close to meeting the preponderance standard.
Well, can I ask you about that? I searched, and I will confess in vain, for anything the district court said that could be plausibly construed as even under the preponderance standard you win. Do you agree that we get sentencing appeals where district courts say, even if I made a mistake about this, I would still do the same thing. You agree the district court here never said, under the preponderance standard, I would reach the same result?
I read the opinion again last night, and just to make sure, and you're right.
Okay.
But yeah, but still, this court can uphold the ruling if there is sufficient evidence.
Well, not if there's sufficient evidence. It
I'm
has to
sorry,
be
if there's
like-
insufficient.
No, well, I mean, I think we have a very strong presumption that if a district court applied the wrong evidentiary standard, we send it back unless I think it's something like it is unmistakable from the record. That like this has to be, it's the only way you could read the record. And I have to say, in a case like this where there's like an actual, pretty charged dispute on this factual question about whether these people are actually making sales or not, and the district court, is hearing contrary testimony on that point, weighs the evidence and says, well, there's not clear and convincing evidence that they are. This seems like a tough case for you, that if the district court applied the wrong standard, we could resolve that factual question ourselves, say that it is unmistakable on this record.
Well, Your Honor, respectfully, I disagree. I mean, there was very little, if any, evidence that they were making sales as a primary duty. Just wasn't there.
I don't want to, can I just, the fact that this is where you're focusing, do you have an argument for why after Encino there is some legal justification for applying the clear and convincing standard? And I want to ask the question this way. I mean, Encino, I understand your argument, these are two different questions, evidentiary burdens, statutory construction. But Encino does say that there's, you don't give priority. There's no textual basis for giving priority to the coverage mandate as opposed to the exemptions. And in light of that, what is the justification for moving away from the default preponderance of the evidence standard, which allocates the risk of error equally between the parties? How is that not sort of compelled by Encino's reasoning, which says treat the exemptions and the coverage mandate equally?
Your Honor, I'm into my rebuttal time, and I may have permission to answer.
I'm not sure you're into your rebuttal time. Is he in
Okay.
his rebuttal time?
I'm sorry,
No.
I misunderstood. I'm very sorry. Red is, I'm out of time. I apologize. I just don't see any connection at all between the evidentiary burden and the construction of the statute, implicit or explicit.
None? I mean.
None.
To continue with that rule of lenity, presumption of innocence, I mean, would we really say that in criminal cases, the rule of lenity has nothing to do with the fact that the burden of proof is also on the government? I mean, it seems to me those are pretty clearly connected to each other.
Well, there isn't a single case that I've seen that makes the connection.
Okay, let me just try
between-
asking the question this way. You agree, right, the default evidentiary burden or evidentiary standard in civil cases is preponderance of the evidence.
Yeah,
And it
yes.
is so because that means that, you allocate 50-50 the risk of error between the parties. What would be the justification for departing from that in this case that is consistent with Encino? What would you tell me? What is the reason we should use clear and convincing instead?
Simply because that's the established precedent here.
But can you give me, understood, but can you give me a justification for that that would be consistent with Encino? Or is your position no, you really can't justify this under Encino, but that's okay because you still have your precedent and it wasn't overruled?
You can justify it,
Okay,
Your
how?
Honor. And the Supreme Court has said for years that this is a remedial statute. And it's designed, to cover employees, to compensate employees for overtime. It's remedial in nature. It should be construed liberally.
But that's
But not
exactly...
construed liberally anymore, because now
Right,
Encino says we don't.
that's what Encino overruled all of that.
Well, just giving the regulations of fair reading, I don't think necessarily departs from the principle that the statute is still remedial in nature and construed in that fashion. I mean, it's a fair reading. It's not that the exemptions are given a broad reading. They're just being given an intermediate level fair reading.
No, but, so let me take a step back. Imagine for the sake of argument that this was the en banc court, not a panel. And I say, the Supreme Court has said over and over again that in civil cases, the default burden of proof is preponderance. And in fact, I think in every time the Supreme Court has encountered this question in the last 2 decades, they have said it is the preponderance. Every single time someone says clear and convincing, they say, no, it's preponderance. Because for all the reasons Judge Harris said, what would be the reason why this? So the only one of the few I can think of at this point is New York Times versus Sullivan. And we say, well, that's because the First Amendment is really important. And it's exceptionally important to make sure that members of the press reporting on public officials aren't deterred. What would be why is this different than the ADA, Title VII, 1983, all kinds of other statutes?
Because workers need to be protected. And for the employers are held to, a high standard. And workers are often, people of not of significant means. And it's not unreasonable to require an employer who created the position in the first place to prove it by clear and convincing evidence that the person is exempt. The burden should be on the employer and it should be substantial. I'm out of time, unless the court has any questions. Thank you.
Thank you. Mr. Garcia, you have a few minutes.
Thank you. Your Honor just saw exactly what I was saying. There is no basis for maintaining the clear and convincing evidence after Encino. And I will note, the only argument that was posited by counsel was the remedial nature. Again, this question was asked and answered by Encino. The court.
So doesn't that sort of leave us, I really do struggle with this, with the question of whether we, I do think this comes down to when do we say that something has been kind of implicitly superseded?
I'll tell you, Your Honor.
Okay.
His statement was, this is a remedial measure. The court said, the narrow construction principle relies on the flawed premise that the FLSA.
You guessed at what my question was, but you guessed wrong. That was not my question.
My
My
apologies, Your Honor.
question is, I thought you were going to read me something about what we have said about when we consider our precedent to have been implicitly overruled. Assume for the moment that I agree with you, that starting today, I can't come up with a justification for Desmond that is consistent with Encino. Do I need to? In the posture we find ourselves in, do I have to think
So in Payne v. Taslimi, which is also in our brief, Your Honor, the standard is when the Supreme Court decision clearly undermine a panel precedent, there is no deference. So clearly undermine, again, it has been, in our opinion, entirely undermined by Encino. There is no justification that can remain for keeping the clear and convincing evidence, let alone the fact this would be the only circuit in the country applying the clear and convincing evidence at this stage. As I mentioned, all of them have tracked that direction. Some of them have posited the question and not fully answered it. This would be the only circuit affirmatively saying, no, despite what Encino is saying and overruling all of these years of precedent of narrow construction and all this rationale for making this act tougher on employers, we're still going to apply this heightened standard. I believe that would be.
And you think this is a case where we couldn't avoid it because this isn't a case where the district court judge said the standard of review ultimately, the standard of proof ultimately doesn't matter here because I'd reach the same result either way?
That's exactly right. It's unavoidable here. In fact, and I know opposing counsel disagrees that we provided no evidence, the district court in a number of situations stated we met the clear and convincing evidence standard for certain aspects of this, and for other aspects of this, it acknowledged that there was a possibility. Now, is possibility 51%? Only Judge Bredar is able to come up with that conclusion, and is possibility plus the fact that in others there was clear and convincing, that's tough for us to decide. So again, we believe that the clear and convincing standard has been clearly undermined by Encino and shouldn't be pursued any further. Again, I want to get back to the willfulness argument. The opposing party tries to completely ignore and apply Richland Shu's standard at the same time while ignoring it, stating the fact that she knew about this, that's it. Richland Shu says the opposite. Just because the person knew the FLSA was in the picture is not sufficient. You need more. And even the Chow case, which is repeatedly cited by the employees, in that case, the company was told by the Department of Labor that there was a violation, but the court found that was insufficient because they didn't get told what specific statute and they didn't get told how to fix it. In this case, there's no evidence that EMD affirmatively knew they were operating in the wrong. And in fact, that goes back to the good faith component that the court solely and unfortunately myopically focused on the actual knowledge of Ms. Devari as being dispositive. There is a plethora of case law cited in our brief that in similar situations, courts in other circuits have stated that even if the employer doesn't have specific knowledge, and I'll cite to Rudy v. City of Lowell, when an employer's decision is made above board and justified in public, such as during collective bargaining, the employer is more likely to have been acted in good faith because double damages are meant to apply for concealed situations. So this court should provide guidance to the district court to say it was erroneous in finding that it was dispositive on the actual knowledge component. The other factors, collective bargaining, the lack of complaint, reliance on an attorney's silence on this issue, and that if you hire an attorney, they're going to comply with the law. All of these are factors that the court should have weighed and not necessarily focus just on the fact that Ms. Devari did not have the highest level of knowledge, but the court did acknowledge she had some knowledge, even if it was at a high degree of generality, and even if it stated that some of it was aspirational, she was herself the first salesperson. So for those reasons, Your Honor, we would ask that you reverse the court's judgment on the two issues that we cite and affirm on the one issue on the other side. Thank you all so much for your time.
Thank you, Mr. Garcia. Mr. Leahy, you have a few minutes.
Thank you, Your Honor. So one important thing about the Chow case, and I hope I'm pronouncing that correctly, is the district judge made a finding that the employer did not know about the requirements of FALSA, despite the interactions with the DOL investigator. So that factual finding was binding. And of course, if the employer had no knowledge of the requirements of FALSA, they couldn't therefore be a willful violation. I agree with that. The opposing counsel has mentioned the collective bargaining agreement. There was a collective bargaining agreement, the most recent one being in 2015. All the testimony at trial was the issue never came up. So the collective bargaining agreement doesn't factor into the good faith analysis, and it doesn't factor into the willfulness. It doesn't factor negatively into the willfulness argument. But I think it factors into it in the sense that this employer had all the means and the ability to figure out that that they were violating FALSA and failed to do anything. Never took it up with the union, no testimony that the lawyer who was by her side during trial and during collective bargaining discussed it with her, one way or the other. She gave some amorphous testimony that I had the right to rely on silence, but we don't know whether there was silence or not because there was no testimony specifically on what those communications were. So the collective bargaining agreement does not support a finding of no good faith, and it does not support a finding of non-willfulness. Unless the court, and I will go back for a second to the Encino Motors issue. I don't think my response was very complete about the reasons why the clear and convincing standard should be in place, the rationale for it. And that is that the employer holds all the cards. The employer creates the job. The employer decides not to pay in accordance with FALSA. And the employer should be the one to clearly and affirmatively prove that the employee is exempt. And unless the court has any further questions, I don't have anything further.
Thank you, Mr. Malahi. Thank you, Mr. Garcia. The court is going to stand in recess. We'll come down briefly and greet counsel and be recessed until this afternoon of the ceremonial session.
This honorable court stands adjourned until this afternoon at 3 p.m. God save the United States and this honorable court.